Life, Loss and Legacy is a general information podcast only. This does not constitute professional advice as we simply don't know your individual circumstances. If you do have any questions, please be sure to contact the guests of the episode. It should also be noted that the opinions expressed by the guests and host of the podcast are theirs alone and do not represent the opinions or perspectives of their employer or any other associations. That's enough warning. Let's get started. Hello and welcome back to Life, Loss and Legacy, a planning solo podcast for people in the first 3 years following the loss of their partner. My name's Jordan Vaka. I'm an independent financial planner, and I'm joined today by Teresa Catalano of iWills Legal. Hello, Teresa.
Hi, Jordan. How are you?
I'm very well. I'm looking forward to this discussion because we're talking today about estate litigation, which I think is such a big, scary topic for a lot of people in this space. Hopefully we can take away some of that fear, some of that apprehension.
Yes.
Before we hop in, I'll run through a very quick CV because you've done quite a lot. Teresa is a Wills and Estates accredited specialist in the state of Victoria and have been for a while. You established iWills Legal in 2017, and before that, you were a partner at a very prominent top 10 Australian legal firm where you cultivated and built their Wills and Estates team. Your expertise is in Wills and Estates. You've done quite a lot in the administration and litigation space. We have talked offline about your work through the VCAT process and some of the guardianship work. We won't be touching on that today, but it is a very interesting space. Thank you so much for coming on and talking about this.
Yes.
Now, we are going to cover 3 different areas when it comes to this, as we have done through the series. Primarily, we're going to talk about what is an estate dispute, when does it become relevant for people, what is the path from kind of an initial disagreement or dispute through to a final hearing, and then we're also going to hopefully bust some myths, but maybe also just open some people's eyes, because we were talking just prior to recording, and you left me with a few "whoa, what?" moments. So it's going to be very, very interesting. So we'll hop straight into it. Enough preamble. The big question: what are some of the common triggers that sets people down this path towards litigation?
Well, there's a few. Badly drafted wills can lead people to then litigating estates. The higher incidence in our society of blended families now, and the challenges that brings in terms of apportioning different, inheritances and assets across the broader blended family. People being promised things, I guess, during the person's lifetime that's now died. That's very common, especially in farming families. Actually, I know we're not probably touching on that today.
Yeah,
but
okay.
that often leads to a lot of litigation regarding farms and things generally being promised to, adult male sons versus, the widow or other, female children in that family unit. So there's some of the things, I guess. A lot of other grievances often come out later in life in terms of if children, even in a nuclear family unit, were treated disproportionately by their parents. So let's say, one child went off to private school and one had public school education. Now they're in their 50s or 60s and they're quite aggrieved by that.
And the estate can become a way for them to sort of exercise those demons a little bit.
Correct, absolutely, because you have to really dig up all of that history and go through that with them. So, that would be the main issues.
I've got some follow-up questions around kind of those reasons, but just as a practitioner, as a lawyer, when you're confronted with somebody whose driver to dispute the will is primarily emotional like that and is rooted in a long sort of history of things.
Yes.
How do you assess, because part of your job then is to assess the validity of their claim, isn't it?
Yes, correct. Yes, and we have to, as practitioners, there's certain forms that we have to complete for the benefit of the court. So if the claim has no merit, we are not allowed to take that on or advise the client to actually take that claim further in terms of bringing a formal claim, because there's serious ramifications not only for that client, because they also have to sign a certain certificate for the court to say that the claim has proper basis, but also we as solicitors have to do the same. So there's ramifications for both of us and also cost implications that can then result.
So does that mean estates, and I know it is a difficult space emotionally and professionally,
yes.
Does that mean there's fewer, vexatious or just meritless claims? Is that less of an issue in this space of law?
It never used to be. Just being frank, Jordan, years ago, until the law got tightened up a bit in this space, it was actually far easier for vexatious claimants to come along and have a go. I know not so long ago, look, probably about 10 or so years ago, it was even, the neighbour, the next door neighbour that would have a go, or someone who was in a paid carer's capacity. You might have seen some of these wonderful cases on the news at the time.
Mm.
And as a result, our laws were tightened to do away with those sorts of vexatious claims, which is a great thing. So now, as a result of the tightened laws, particularly in Victoria and New South Wales, it is very hard for those claims to actually get brought. You will find that at times people will have a go, though. It doesn't mean that you have to file your claim within the court. For example, to contest a will in Victoria, every state and territory in Australia has different laws around this and the timing and the requirements. But in Victoria specifically, you've got 6 months from the date of the grant of probate to contest a will. So within that time frame, you'll often find that whether it's the family members amongst themselves or via lawyers, there can be negotiations that take place and discussions without necessarily needing to formally bring your claim.
Right. Yeah,
Which is a
right.
good
Okay.
thing. Which is a good thing.
Yeah.
So just on that, just following through on that point, it means that some of those, perhaps unmeritorious claims can sometimes still succeed if people are willing to settle with them at that
Mm.
point. But if they had no merit, they really couldn't take it further, just in case they didn't succeed by way of negotiation.
All right. Okay. So I
Yeah.
mean, putting myself in the shoes of the executor. Let's. I mean, I know it's not. It's a stretch because I think in Victoria we have kind of defined who can lodge a complaint,
Correct.
claim or
Correct.
something
Yeah.
like that. But let's say it is the neighbour, which I know it can't be. Let's say the neighbour lobs a claim. As an executor or as a family, we can say, look, if we pay them X go away money, they'll go away. But if we refuse to, they then can't take us to the next stage in the dispute.
Couple of things. So if you were the executor and you got presented with a claim that had very little merit, you would force them to file their claim through the court.
Yep.
If it had no merit, most of them wouldn't go to that stage if they had no merit. But if it had no merit, you'd probably be advised as an executor to try and apply to have their claim struck out. So then there is no claim. But if there was no claim or very little, no merit or very little merit, you wouldn't even negotiate with them as the executor. You would be just having to stand your ground and saying, well, we're not negotiating, take it all the way. If you've got a claim, prove it. And the way you prove it is on affidavit. So that's effectively that claimant going on oath saying, this is the basis of my claim. This is why I'm eligible. This is my financial and medical need. This is the circumstance, etc. And then they will be advised by their lawyers as to whether or not it needs to go forward or they can try and resolve it. But yeah, most of these cases in Victoria particularly settle at the mediation stage and they don't go beyond that. That's if they don't settle beforehand.
Going back to the triggers that you flagged, and there were 3 really big ones. Badly drafted wills. Can you give us some examples of kind of what's a red flag for you with a badly drafted will?
So they can get beneficiaries' names wrong, as stupid as that sounds, or property details incorrect. That then
Are we talking minor misspellings? Are we talking?
Oh, it could be minor, could be major. The word "the" that's omitted from a clause can make that clause have a different effect, which then has a different flow-on effect and different impact. And then there's a construction issue with the will. So it could be the incorrect property was referenced and might be still one of the deceased properties, but it's the wrong one. It's not the one they intended to go in a particular way. So there can be clear negligent omissions, and it's often the drafter of the will. It's not necessarily the person who's died's fault, obviously. And there is recourse, but it's costly and it's a process that has to be followed. We are seeing a lot of wills where there are people, unfortunately, that are drafting wills that shouldn't be. And we're seeing these common simple mistakes that just shouldn't be there that then result in unnecessary litigation and flow-on effects. We're also seeing things as simple as the will not being witnessed correctly or signed correctly. And if a will doesn't follow those formal signing requirements, if the estate's 3 mil plus, you need consents from the affected beneficiaries named in the earlier will, as well as those that are in the last will. So often you can imagine if there are beneficiaries that were in an earlier will, but are no longer named in the last,
They're not
inquiry
going to
of
sign off on
signing. They're
that.
not going to sign it. So again, it goes off to court. So it's quite problematic. So ideally, you'd want to be signing those documents, correctly. And during the pandemic, the electronic signing laws
Yeah.
caused us some issues because most of those wills aren't getting through because they didn't comply or adhere to the formal
Really?
ones. Yeah.
So just as background, during the
Yeah.
pandemic, as wills were being drafted, because we couldn't see people in person, the witnessing is it's countersigned on every page, is it, of a will?
Yeah, so if you were signing a physical will, it's basically the will maker has to sign on every page, and there
Hmm.
has to be two independent adult witnesses that countersign at the same time. So they're meant to be using the same pen in each other's presence, signing the will together on every page. Correct,
Which
and
during a
obviously
pandemic,
wasn't possible. So initially, until the emergency electronic signing laws came through in Victoria, we were just having to meet people at parks, as bizarre as it was, and having to get neighbours to come along. And so everyone was socially distancing at the park bench and getting it signed. But then from April onwards, we had the emergency laws that came into play that did allow us to sign things electronically. So using things like Zoom and Teams, we would share each other's screen. We would use programs like DocuSign. But a lot of those wills are not now getting through to probate because the probate registrars aren't satisfied. And there was a case that tested all this, that the will maker's hand was on the mouse or, the device that they were signing with, or the pen or whatever it was that they were signing the electronic will with, at the same time as being viewed on the camera. So basically, you had to view them or their face and their hand physically signing that electronic document, which most people weren't set up to do or weren't
no,
aware of that.
no.
So that's why a lot of them aren't getting through, unfortunately. So the only way to get them through is as an informal will, which now,
Oh,
if
God.
it's under that sort of threshold, you can get them through. If not, you need the consents of those affected beneficiaries in a prior will. So
That's,
it can be an absolute mess. And then despite that, it doesn't stop someone contesting. So it doesn't matter which will gets through, someone can still contest the will.
a probate has to be granted before a contest can be raised. Is that fair?
Correct. Yep.
Yep.
So, and probate on average takes about 2 to 3 months if there's no issues, but you can force an executor to get probate or be passed over if there is an issue or if they're delaying it just to stop you filing your claim. Absolutely. But the thing to be aware of is you can only contest the assets that form part of the estate. So if there are assets sitting in a family trust or super, directed by way of a valid binding nomination, to a dependent outside of the will, those assets can't be attacked in a will contest claim.
Just on the point of the family trust, and we won't spend a huge amount of time on this, but it is a rabbit hole. We spoke about this when we caught up recently. And it all echoes back to this point, and it's been a theme through this whole series, is that we need to engage specialist practitioners in this space to make sure that mistakes aren't made or minimize the chances of mistakes being made.
Mm-hmm.
You walked me through a scenario where a family trust asset can be brought back into the estate. It can be challenged. I think it was something to do with, I forget, it was the construction of the family trust. It hadn't been done by a lawyer.
Okay, so I think I know what you're talking about. That was a more about the asset protection, actually, and I'll get to that. But
Yes, that's
in
right.
terms of, no, that's okay. But that is important too. But parking that issue for the moment, going back to what part of the trust can be part of the estate, it would be if there was a debt or an unpaid present entitlement that was owing to that deceased person on their death, and it hadn't otherwise been forgiven during their lifetime, and the will doesn't then proceed to forgive that debt or unpaid present entitlement, then that part of it, or whatever the value of that is at the date of death, is an asset of the estate. And that is then part of what can be challenged in the communal sort of will contest sort of environment. But the trust itself, the control, the assets of the trust, etc., can't be.
Okay.
So that's
I think it's a sleeper issue. I think that's, sorry to cut you off, but I think
that's right.
the people that we work with are the people that aren't involved in the nitty gritty and the day-to-day running of all the different entities. And so then they get quite surprised when they realize there's actually a beneficiary loan account that's been built up in the trust of $500,000 or $1 million.
Correct.
That now is just sitting there as part of the estate and they have to work out a solution for. I think it's something that really needs to be flagged more often.
And absolutely. And we're seeing some issues where it is a function of accounting, as you and I know. And sometimes those debts or unpaid present entitlements, it's not possible for the trust to pay them.
Yeah.
because the trust has a huge tax liability, for example, or the assets are will need to be liquidated but can't be for various reasons. So that poses other layers of issues in terms of them being able to get it. But one thing I think that you were getting at, Jordan, just going back to your earlier question that you and I were talking about, it's more around, so you've got your typical discretionary family trust and your trustees are in control of it. And back in the day, you would say, okay, well, the trustees have completely unfettered discretion as to where they distribute and to whom in the class of beneficiaries of that trust, income and capital. But now there's a case that came out that challenged that discretion. And basically said that yes, the trustees do still have discretion. However, they must consider the needs of all the beneficiaries. And if they're not considering the needs, then a beneficiary can basically call them into account and say, hey, I've got this financial need or this medical need. You didn't consider me in this particular distribution year. You need to give me X amount, or I'm, going to challenge this and get you removed as a trustee. So there's other layers to that now as well, which is separate to the will contest and the estate litigation, but it's just something to be aware of.
That's huge. That's
Yeah.
massive. I think it's, yeah, I mean, we'll park that because that is huge.
Yeah,
But I think for
that's
anybody
another
listening
issue in itself. Yeah,
that has
yeah,
family trust, or because the contesting of a will, it plays into normally a larger family narrative of, needs not being addressed or met. If there's a family trust involved, that's definitely something to flag with, whoever people listening. If you're talking to a lawyer
yes.
or an accountant, that's a really interesting case. Or reach out to Teresa. So badly drafted wills, and I think it does come back to that point of engage a specialist, because there are, I'm going to tread very carefully here, there are generalists that will do a little bit of everything. But my read of wills and estates, or any area of law really, you can't afford that. You're better off paying a specialist a little bit extra now to have confidence in your documents. Is that fair to say?
Correct. And confidence in the legacy, particularly in this space. And of course, I'm biased because wills and estates is my area, obviously. But I think it's not just confidence in, the documents you leave, but the legacy you leave to those that you're wanting to benefit, whether it's charities, whether it's your relatives or friends, whoever it is. If you want that absolute certainty, that peace of mind, even though I appreciate you won't be here when this all sort of eventuates and comes to fruition. Well, the only way you can do that is with proper guidance and advice, like anything in life. And, and I use a very practical example sometimes about, and I may have discussed this with you before, Jordan, but, if you had a heart issue, you'd see your GP. Absolutely. GP would look at you and say, okay, I've gotten you to this point. I've assessed that you need surgery or whatever it is. You need to go and see a cardiologist. Who would you want to operate on you? Of course, not the GP. You'd want the cardiologist, the specialist. And same in wills and estates. I think, there is a place for will kits. There is a place for, your generalists, absolutely. And it is better to have a will than not to have a will. That goes without saying, no matter who's doing it for you. But I think, and I've been practicing in this space for just over 20 years now. And I think over the years, I've seen quite a seismic shift in terms of it's not as easy for people to dabble in this area of law as it used to be. I think that back in the day it was absolutely anyone could do them. I don't disagree with that. Now there's a lot of moving parts. There's the, people are dying with more and more money in super now, right?
I think that's a big thing. The wealth is a lot greater now.
But it's how it's held as well. It's not just about having greater wealth. It's how you hold it, because super, as I said before, doesn't necessarily form part of your estate, right? So people think, oh, I've got a will, fantastic. It deals with my super. It deals with my family trust. It deals with, interest in a unit trust or whatever it is, or my joint properties. And that's not the case, right? So if you're doing a will kit or you're getting advice from someone perhaps who doesn't have that experience, then you won't understand what you don't know, if that makes sense. So I think that there's those moving parts. Obviously, the blended families, as I touched on before, again, they those issues and how you balance out your inheritance amongst various people in your family group is becoming more and more important. There's different tax consequences of distributing different assets in different ways.
Can we expand on the blended families piece a bit, please? Because I think one of the things that impresses me about people working in estate law is that you need to draft documents that need to take into account possibilities and potentialities that are 30 years down the track. And I would freeze. I would just clam up when it comes to it. But blended families, you are looking at, two parties that have perhaps remarried, so they've got children from former relationships. Some of those children will be adults, some of them will be children.
Yes.
What are some of the areas where that can lead to a dispute? Which is one of the silliest questions I think I've ever had to ask.
No, I mean, lots of areas, really, just everything. It's all up for grabs, Jordan, really, when
Yeah.
you get to that point. So I guess the spouse will always, or the current spouse at the time that person has died, will always be considered by the courts to be the person that you had the greatest obligation to provide for on your death. Primarily against or balancing against adult children's interest from a prior relationship, right? But if you had minor children to someone else, that's different. But if you had, let's say,
The idea being that the adult children have been catered to previously.
correct,
They've been
correct.
shepherded to adulthood.
Correct. And generally speaking, I mean, whilst parents always want to look after their kids no matter what ages they are, there is no obligation on a parent beyond a child, turning 18 to legally provide for them necessarily. I mean, obviously parents do, but obviously there are things, and I'm just speaking quite generalistically, because some adult children have needs, or they could have severe disabilities, they could be drug addicts, they could have financial needs, whether it's through fault of their own or not, doesn't matter. So obviously those issues would have to be balanced out and considered as well. So this is not sort of it's a very generalistic, broad brush view that I'm giving you. But if that didn't exist and you had adult children that were fairly self-sufficient, and versus a second or third subsequent spouse, male or female, the gender doesn't matter, then the courts would consider that spouse is the person that you had the primary obligation to sort of look after and provide for. And there have been many cases that have shown that, unfortunately, and the way to then, I guess, navigate that is, generally speaking, if that spouse has got a lot of assets of their own, properties of their own, a significant financial nest egg that can help them live for the rest of their life, then that helps weaken and diminish the merit of their claim. It's not to say it's, without merit, but it helps decrease the quantum of what they would get. But otherwise, the courts are very sympathetic to those spouses.
We've had a client in the last 12 months. She was disinherited from her mother's will, and the reason given, there's two siblings. The reason given was that she had just divorced her, abusive ex-husband and received a large settlement, and so the mother disinherited her from the will. So there was a challenge discussed, but the legal advice was you have money in the bank that's beyond your immediate needs, so you're
correct. And that's a bit different because that's siblings against each other, different context to another, spouse from a blended family. But
true.
Absolutely. I mean, whether it's in a nuclear family and trying to mitigate like that client you're talking about, there could have been ways that that particular client could have transferred assets out of a name before she died. So it then diminishes the pool that can be attacked in a will contest. So if you're worried, so whether it's your, anyone listening to this or people at large, if you're worried that someone might contest your will, the only way to make that sort of sure-proof is to actually ensure that what passes under your will is very little.
Yeah, okay.
Things out of your name. Obviously, that can sometimes carry, stamp duty or capital gains tax consequences, obviously, and it may not give you the tax planning you need during your lifetime, and it may not be sensible from that perspective. But balancing it out with, how do we ensure that things aren't challenged when we die? That is really the only way to ensure and navigate that point.
Are there avoidance provisions like the contester can claim, oh, that was only done to defeat the will, or to defeat my potential challenge, or is that not a consideration?
Not in every state and territory of Australia except for New South Wales. In New South Wales, they've got notional estate provisions, similar to the bankruptcy provisions. So if the claimant or potential claimant can satisfy the courts there that this person only transferred a property outside of their name before they died to defeat a potential family provision claim, then the courts there have got the power to claw it back in as notional estate and consider it in that settlement. But everywhere else in Australia, you can't do that at this point in time.
Okay. That's fascinating.
So that's why it's very effective if you are employing that strategy. Yeah.
You mentioned in their family provision claim, that's very much that what we were talking about, that you didn't provide sufficiently for somebody's needs or conditions. Correct. And that's where the court would make that assessment. They're weighting up the different obligations the deceased would have had. The third reason you mentioned as a bit of an estate dispute trigger were promises, particularly in farming
Yes.
families. But
Yeah.
what are some instances where a promise can maybe be made that would lead people to think that, and how is that then dealt with in the dispute process?
Yeah, so that's not necessarily, it can be dealt with more cost effectively and often more efficiently through a family provision claim. Because dealing with it, there are other types of claims,
Oh,
like, promissory estoppel, for example, without getting too much into the technicality of it, that you can, bring, or a constructive trust claim against a property to assert that you have some, that the deceased was holding that property on a constructive trust for you. You can bring those types of claims, but they're very expensive and there's a lot of evidence required.
mm,
So more often than not, as sort of a difference, route, you'll end up doing it via a family provision claim if you can anyway, because it's more cost effective and the estate will generally bear those costs. But an example, like I said, a key example, and we see it all the time, is in farming families. So a particular child in the family may have been promised the farm on the basis that they're the ones that, whether they move in and live on a particular property on the farm, or they effectively run the farming business for the family
they
or
stayed
together
on
with the
the land.
correct. And they run it with or for the benefit of the patriarch or matriarch of that family, on the basis that they might be paid a very nominal, income or wage, but there's promise that, don't worry, you'll be looked after, you'll be left the farming property and the farming business when we die. And then lo and behold, that's not done. That can be not done for different reasons. It could be a problem with the will, it just wasn't thought out properly, back to our earlier discussion, or just because they've since lost capacity and they never updated their will in time, and then they've lost capacity and it's too late, and that person was stuck with that last will. Or as people age, we're seeing that they do get more influenced. The elderly are more
Mm.
vulnerable, unfortunately, even if they are still cognitive, and they can be influenced by different people in their lives, friends, family, or otherwise. So all sorts of different reasons for why then it doesn't translate into that person's last will. But that's that's their largest example of why those particular children then feel aggrieved and contest the will.
And then that evidentiary requirement you said, I mean, proving a promise, proving a verbal discussion can be very challenging. So that's why the other
Absolutely.
paths are probably a bit.
And they're very expensive types of or claims to bring. The family provision claims are more cost effective, as I said, so it's not just about the evidentiary burden. But you're right, a lot of these, you can imagine between family units, most of these discussions, especially in farming families, which are often, legally unsophisticated, they would just be sort of, on the fly discussions. Oh, I'll
Yeah.
give you that, just, but you've got to move in and do X, Y, Z. There's
Yep.
never anything documented usually to support that, proposition.
Through the dispute process, I mean, it's also, I think, a good time to talk about who's who in the process, who's actually
Yes.
involved in it all.
Yeah.
So let's start with, you've mentioned will maker, I think I'll call them the deceased. They're the same person.
Yep.
Testator. Is testator, is that,
Same
where do they
person.
fit in?
Testatrix, so it was just male or female. Yep, same person. Yep.
Um, who else have we got? So then we've got beneficiaries to the estate.
Yeah, and the executors are people that are entrusted with, effectively calling in your assets, paying any liabilities, and administering the estate as per your will. But if there is a will contest or any sort of litigation against the estate, it's your executors that have to defend that litigation. So they are a party to it. So obviously the person who made the will has died, so they're not there, but it's the executors and the beneficiaries that need to settle and resolve any type of litigation or dispute.
I think one of our former guests used the phrase, I think it's common, stands in their shoes.
Yes, that's a good one. That's exactly right. So it effectively, we used to be able to say it's a piece of paper. Now it's an electronic document. It's not as fancy as the court sealed parchment anymore, but that document effectively gives the executor the legal authority to stand in that deceased person's shoes and deal with their estate.
In the event of a dispute,
Yes.
beneficiaries can dispute, non-beneficiaries can dispute. They would go to an estate lawyer, estate litigation lawyer, I assume.
Yes.
Then there's mediation. There's a mediator involved in that. And we'll walk through the path to
Yeah.
final hearing in a moment.
Yeah.
Who else in the process of that dispute step or initial phase? What's another sort of terminology for somebody who's involved in that process that people may not be aware of?
Well, the people that are generally involved, I mean, just to go back a step, the parties don't strictly need lawyers. It is very uncommon for them not to have lawyers, though, just to be crystal clear on that. So generally, the claimant, whoever's challenging the estate, whether they're a beneficiary or not, doesn't matter. They would have their lawyer from day dot, usually, to get that advice. The executor would have a lawyer that's been acting for the estate that help them get probate, help them deal with the administration of the estate, that helps them navigate that process. And then the other impacted parties, being the other beneficiaries of that will, they don't necessarily need their own lawyers. If they feel that the executor is representing their interests sufficiently, they can allow the executor and just sort of hide in the background, but still be part of any mediation down the track, but it just conserves costs. And then the process is that, the claimant files their claim in the court. There's a procedural hearing where a timetable is effectively set down for things to happen. The claimant has to file an affidavit, which is them just on oath supporting or basically setting out the basis of their case. The executor then responds. If the executor is not the sole beneficiary, they may get other parties like the other beneficiaries to respond or to assist in that process. And then the claimant has another chance, if they want, before the mediation that's scheduled, to respond further. It's not common, but they can. And then it gets set down for mediation. At the mediation, again, you would have the claimant and their lawyer, the executor and their lawyer. The beneficiaries would be part of it. They don't necessarily need separate legal representation. And you would have an independent lawyer who acts as the mediator that day, that goes between the parties to try and get it resolved.
And how do you choose the mediator? That's something that I think maybe isn't well known.
It's a good question, and especially in these dynamic family matters, we often have to match the mediator to the personalities of the individuals we're dealing with. It is done by mutual consent by the executor's lawyer and the claimant's lawyer. They have to jointly agree.
So somebody will come up with a list, the other person will vet the list.
And you sometimes settle somewhere in between. But yeah, often there's a bit of argy-bargy about that sort of stuff because everyone sees it. Or there's certain, barristers at the bar that might be more claimant friendly and others that are more estate friendly. So you kind of want to find the one that matches the person you're fighting for on that particular day. But most of the mediators we have in this space are very experienced and very good at, and like I said, we're generally successful at trying to get it settled that day. And if it is settled that day, terms of settlement are drawn up on that same day. So no one leaves without signing up legally to the deal, whatever's been agreed to.
Okay, that's great. We've been involved in some mediations on the family law side, and it's obviously two parties, disputes, that. But in the state, the parties can multiply. So I think the problems and the challenges are exponentially more difficult. So hats off to the mediators out there.
Absolutely. Couldn't agree more. And I'm not a mediator myself, but absolutely. I think they have to have a lot of patience, but, have to have a lot of commercial nous as well to be able to just say at the end of the day, unfortunately, and probably not dissimilar to family law, but when it comes to wills and estates, you can imagine there's a death involved. So people are often still grieving. Yeah. But aside from that, there's real people and real relationships. It's not like a commercial claim where you're suing your builder for a defective, build. Yeah. So it is very emotionally driven. So the job of the lawyers acting for each of the parties, as well as the mediator, is to try and step back and not get involved in that emotion, to not do our clients a disservice, really, or the parties a disservice, and to try and just say, guys, let's just try and be practical about this. This is what we're dealing with today. If you go on further, you're going to spend X amount more in legal fees, drains the estate further, potentially affects the relationship you have with your sibling or your step parent or whoever it is we're talking about. Just be commercial. It all comes down to numbers at that point, unfortunately. Let's just try and resolve it. It's not worth fighting over a $200 chair. Do you know what I mean? Yeah.
I think you've touched on a really interesting point there that I think there is kind of that cliche idea that, the lawyers picked apart the estate. And it's this, you guys get tarred with this brush. But I think part of it is that claimants or people in the process don't feel like, they say they don't feel heard. But when you dig under it, it's more like the lawyer wasn't just my mouthpiece. They didn't just do what I wanted them to do. And I think it's really important we make it clear. That's not your role, is it?
No, we are not. And barristers have different obligations, again, to the court particularly as well. And so even in a trial matter that I ran recently, a barrister made it very clear to the claimants that, he had to do what he felt he had to do as well. Obviously took the instructions, but obviously needed to work within a certain, framework, if that makes sense. So, as solicitors, we absolutely need to give our client advice. so they can then make an informed decision based on that advice. But we have our own obligations to the law and to the court as well. So we have to be very careful. If a client's telling us to do something that is absolutely outside the framework of what we're allowed to do, we have to tell them, sorry, we can't do that. We can't just be that voice piece, unfortunately. However, we do work it out. We don't just say no bluntly. Obviously, we work through, it's not like that at all, despite what people might think. We absolutely work in a nurturing way with our clients. We have as many meetings as we want. We understand that not everyone has been through litigation before. We understand it can be scary. We sometimes say to clients, do we want to try and resolve it before even a mediation, or even if we got to a mediation, we're like, do you understand the emotional burden this might carry for you if it goes on to a trial? Let's work through this. So we look at it practically from their perspective as well, and try to give them insight that sometimes you just, for peace of mind and closure for yourself, you kind of just have to draw a line in the sand, whether it's fair or not. Life is not always fair. The law's not always going to be in your favour. But what's worth, your emotional sort of peace and closure, just wrap it up basically. Sometimes you just have to.
I think it's a fine line that you have to tread, in that you need to be dispassionate in representing the client's interests, but also nurturing and empathetic. And I think that's
correct.
It's very, very challenging. That point you just made there of what non-financial costs could you be carrying as you go through the litigation process, and is it worth it? As a very general and broad stroke, how long does the litigation process take from initial dispute through to final hearing?
It's a good question. So most of these, as I said before, settle at mediation stage. So from the time that the claimant files their claim to mediation, you might be looking at up to sort of 4 to 6 months. But if it then had to go on for trial, to be listed for a trial date, it could be, depending on the court's backlog, it could be up to a year to 2 years beyond that 6 months.
When you're just sitting in limbo.
Correct. But again, and we've had many of these matters too, there is still more than one opportunity to get it resolved before that trial. So even if it is listed for trial, even if the lawyers have to go off and incur cost and expense in terms of preparing the matter for trial just in case, there are many touch points and opportunities for the parties to still settle, and sometimes they do. They just go, we don't want to wait another year or 2 years. We want we want to move on. And then they start to get it, even if they weren't quite ready at the mediation stage. So as I said, it is rare that these matters end up at a trial. However, having said that, I've noticed since the pandemic, and again, I don't have any recent stats because it's still, the last couple of years since the pandemic, but I've noticed that there are more parties that are willing to take it to trial.
Interesting.
So
people are a bit more fixed in their perspectives.
Fixing their perspectives. I think the pandemic, and so I'm not certainly not making any sort of socialist views or out there, so I'm prefacing with caution, but I think people have changed. There are heightened sensitivities, expectations, etc. Unfortunately, due to the pandemic and being locked down for a couple of years, it has changed people. It has affected people. I also think people, some people obviously have more of a need for money since what the pandemic did to a lot of people as well. So there is that. What they would have settled for perhaps several years ago isn't what they're going to settle for now, and due to the higher cost of living, etc. So there's a lot of reasons for it, I think.
But it must make it challenging for an executor when you're negotiating with a party who seems very maybe obstinate or just really, really stuck, and they don't care. And again, we'll come to the funding, because I think the funding is a big part of that discussion. That's a big part of it there. We'll loop back to that, but just quickly on the executor piece, and I think I know the answer to this, but the executor standing in the deceased shoes, what's their approach if they agree with the party bringing the dispute or bringing the claim? What can the executor do if they agree with them?
Well, they can't agree unilaterally if they're not the sole beneficiary of that estate, right? Or if they're not prepared, even if they are a beneficiary of the estate, if they're not prepared to fund that claimant's or the extent of that claimant's claim from their share. So if other shares of the estate are to be impacted upon, those other beneficiaries need to agree as well. Whilst an executor has the power legally to settle a claim, they can't do it without reference to those impacted beneficiaries. And if there are minor beneficiaries, the court would ultimately have to approve it.
Minor being children?
Yeah, or just anyone. So whether they're, It doesn't matter if they're related
Oh,
or not. If there are minor beneficiaries of that will that are being impacted, even if it technically settled and everyone else was happy with the settlement, someone has to go to court on behalf of that minor person's interest and get the court to rubber stamp it and say, yes, we believe that this is also in that minor's best interest and we allow for
no.
this to happen. If everyone in play, the executor, the claimant, and the affected beneficiaries are adults, the court doesn't need to get involved and interfere, and they can just all come to their own agreement as to how they settle it. But yeah, other than that, so going back to your other point or an extension of that question around an executor, you can imagine that can also pose different layers of complexity, because if the executor is also a child or might be that second spouse, there's emotion attached to it too. So sometimes the executor can't carry out their role without the presence of that emotion if they are part of that family unit, or they're impacted, or they've got a vested interest in the estate because they are one of the beneficiaries, right? Whereas if that executor is someone independent, like an accountant, financial advisor, lawyer, trustee company, etc., they don't have a vested interest, apart from the fact that they can charge fees, etc., but they don't have a vested interest in the outcome. So that emotion is sometimes not there for obvious reasons.
That's
Yeah.
a really good point, because I think, I mean, I'm speaking for myself here, but the presumption is that you engage a lawyer when you're in an argument or when you're in a dispute. But as I work more in this space, I realize that for people that are maybe naturally people pleasers or are trying to avoid confrontation, they will compromise their interests in order to keep the peace, and then they'll regret that years later. So I think people in that category also really need legal representation to stop them from sabotaging themselves.
Absolutely. And we are seeing, and I know this is not the purpose of today's discussion, Jordan, but we are seeing a lot of executive disputes. So we're seeing many issues with adult children in a nuclear family being appointed as joint executors, mum or dad.
A dispute between the executors.
Yeah, and so we don't even get probate for 2 years sometimes because they're fighting it out. And there still may be a will contest claim that comes later on, don't get me wrong, but it means that the assets sit dormantly. They can't be invested, they can't be realised, they can't be really dealt with until someone's got that legal authority to deal with it. But you've got a problem between two executors that aren't agreeing to anything, so that has to be litigated as well. So this is where I say to people, it's becoming more important than ever to think carefully when you're doing your will. It's not just about who gets your assets, who gets the inheritance, but who controls that. Who do you believe could make the tough decisions? Who do you trust to do what you wanted on your death?
And I think there's some confusion sometimes, I think, for people between an executor and the power of attorney as well.
Correct.
Just to clarify, they are not the same. Could you walk us through just quickly the distinction between the two?
Absolutely. I think the easiest way to look at it is a power of attorney is like your living will, but it only ever has any effect whilst you're alive. As soon as you die, even if it was in play, that power comes to an end. So even if there was a power of attorney that was doing stuff for you whilst you're alive, the power's gone. And the will then comes into play in the nominated executor, if there is a will, of course. That executor can be the same person, don't get me wrong, as who your attorney was, but they still don't have automatic authority to continue acting. Just
they need to have probate.
Yeah, they don't have probate, correct.
Yeah, so they have to change hats part of the way through.
Correct.
And just to clarify for people as well, can a power of attorney make a will for somebody?
No. Absolutely no. No one can. You can't delegate that power to anyone.
So just anybody listening, if that's something that's coming up in your world,
yes, don't do that. We also see issues, I don't know if you remember the Peter Brock case back in the day, but there were issues with that because he dictated 3 different wills, one of which was dictated to his secretary. And even though it went through, there was an issue around delegating your ability to basically nominate where you want your estate to go to. So he basically said, I allow this person to decide where my assets go, and that's void. You can't delegate that. It's not even about delegating the ability, saying to someone, you're doing the will or whatever for me. It's more about in the will itself. I can't say, okay, I give my estate to Jordan, for example, for him then to decide amongst my family and charities, whatever, where he wants my estate to go to. That's not worth the piece of paper it's typed on. Yeah.
It's also quite a crummy thing to do to the person that you're leaving behind, but
absolutely,
you're really dropping them in the middle of it. But
correct.
Yeah, okay. So the will can give the authority to the executor to carry out your wishes, but it does not let them substitute, like to make the wishes themselves.
No, you still have to decide, and in certain terms, where you're in what percentages and to whom, and how it's to happen, specific assets or just the pool of assets where it's going. You can give some flexibility. I don't want to get too technical about it. You can give some flexibility, but the identity of those beneficiaries need to be named, basically.
Yeah, that makes total sense. Uh, Let's go back to the path from dispute to final hearing, because I know that there's a lot of off ramps there that you can go in and try to find a solution between the parties.
Correct. Yeah.
Um, but we're looking at a couple of years if it's a really acrimonious one that goes all the way through to the end. Let's talk a very rubbery number. What kind of costs could somebody expect for that really big one? You know, the one that goes all the way to the court.
Understand. Look, on either side, and it depends on the seniority of the barristers that each party engages as well, because barristers are charged out at different rates as well. But you can be looking at anywhere, around 200,000 on each side if it went all the way.
Yep.
Now, the executor would get their costs from the estate. The claimant, if they were successful in their claim, would generally get their costs from the estate as well. However, it would be on the courts would also, they come in and they have a bit of a supervisory role these days, and they come in and scrutinise each party's costs and say, do we think that this is proportionate to the matter that's been brought, or do we need to shave off some of these costs?
And who carries that shave off? The lawyers
involved, not the barristers, but the solicitors. Yeah. Just to be clear, it's the solicitors that carry that shave off. Yeah.
I'll brush past that because I think that doesn't sit well. So 200 grand each side.
It could be. I'm just saying, give or take. Just very
super rubbery.
Everyone charges differently. There's different methods. It's just hard to say. And it's there could be different little mini proceedings that lead up to that trial. Like, for example, you might put in a discovery application to discover certain medical documents or things you might need. And again, that can add layers of costs as well.
Just on the medical document piece, I don't know. I don't know how estate lawyers feel about the show Fisk, but there was an episode recently where where the deceased Fisk had some questions around their capacity, and so they were able to obtain some medical records.
Yes.
What's the process to get those medical records?
Good question, because you can do freedom of information applications. They do.
Oh, really?
Yeah, you can. You have to show that you've got some connectivity to the matter, though. So you can do it as a relative or as an executor. You're not always granted it, though, because there has to be some nexus to the deceased. It's not, for the world at large. But otherwise, you can make applications to the court to subpoena that information if you can't otherwise get it in any other way.
And that gets that sort of avoids any patient confidentiality or anything like that?
It can. Well, there are certain things that even when you do obtain access to medical documents through a freedom of information exercise, sometimes hospitals will redact certain information. So we have that a lot. So if they give it to us, let's say, and there was and we're acting for a child, and in some of the documentation in the hospital records, there might have been next of kin noted as the neighbour or the wife, they'll redact that information. So we won't necessarily have access to everything.
Okay. But it should just be the pertinent information.
Correct. But if another party has obtained access to that, we can then, in the course of litigation, seek to share each other's documents, or just what's called discover each other's documents, so then we can have access to those things, but only if they are pertinent to the legal issues at hand. So in other words, and back to that Fisk matter, I mean, if we need to know that the will was valid and there is a proceeding on foot about the validity of the will, that stuff becomes very relevant.
I'm right down the rabbit hole now, Teresa.
That's right. Yeah.
How long would it, like, if you decided today that you needed that medical information and you had to go down the subpoena route? What's the rough timeline before you'd actually get the documentation?
You might, it might be just a few months. Might not be that long. Yeah, it's not sort of as bad as sort of setting a matter down for trial.
Yeah, right. Okay.
But again, you may not need to do that. Like I said, we do a lot of freedom of information applications and generally get the information we need, even if it's somewhat redacted.
With the costs that you alluded to, and again, very broad, very rough number. Let's say, let's make it $500,000 between a dispute with two parties. The executor's costs will be funded via the estate, whether or not they're successful.
Well, whether or not who so the executor is always protected by the estate because
Right.
they're in sort of that precarious position where it's not their fault that someone's attacked the estate.
Yeah.
So regardless, the only thing is they can then put pressure on the claimant to settle at an earlier stage by putting in offers in the form of what we call the quarterbank offer and say, if you don't do better than this at trial, then the cost from the date of this offer to the date of the ultimate orders at trial, you have to bear not only your costs, but our costs. So, in other words, instead of the executor's costs coming out of the estate or your costs as the claimant then has the risk that they have to bear those costs if they're unsuccessful.
I learned about these quarterback offers
Yeah.
a little while ago. I think I read about that. I'm like, that's a fantastic, like, that's a great structure, I think.
It is. Doesn't always work because sometimes the offer is a bit under. You can't
Yeah.
always get it
Yeah.
right. It is, I mean, it can work, don't get me wrong, and it would do away with some of those vexatious sort of claims, obviously. But it does still put pressure and risk on that party to
Yeah.
seriously consider what it is.
It brings some jeopardy to it.
Correct. And often, enables it to settle earlier rather than later.
Because I think there is that perception. It's a perception I had until I started working in the space that it is a bit of a free roll. Like you can just have a crack and the estate will cover the whole cost. But it's
It
not quite
used
the
to
case,
be.
is it?
It used to be. Yeah, just to be clear on that, it absolutely used to be. And without denigrating anyone's reputations, obviously there were some people, just like any industry, there were some lawyers that were probably,
Mm,
unfortunately, doing that. And that's probably why now the courts have that quite strict supervisory role. So
mm,
that's no longer possible. So just generally to get to a mediation stage, costs on either side might be anywhere from 20 to 40,000.
hmm
But if the court thinks that, even though they don't know the terms of your settlement necessarily because it's settled at a mediation stage, if they think your costs still aren't proportionate to the type of matter that they're aware it is, they can still shave off costs even at that point.
Do they have like a register or a schedule of fees that you kind of can reference when you're doing that pricing? Or is it more
It's probably
stick a
based on
finger in
what
the
they
air?
see come across their desk. It's also based on the individual judge looking at it potentially as well. So it's hard to say because it's just one person sort of making that call
I,
at the time. And some get through, some don't. So it's
I think we
really
should
hard to
backtrack for
know.
this
Yeah,
before one of us
yeah.
gets in trouble.
Exactly. I'm not saying anything outside of school. I'm just saying it all comes down to the person involved. Yeah,
Yeah.
yeah,
Um,
yeah.
One of the questions I had for you, and I think we've kind of touched on it pretty well, is there a responsibility through the dispute process for the parties to be reasonable?
Yes, there is. There's absolutely, in accordance with our civil procedure laws, both for the lawyers and the parties involved, they have to sign up to certificates on that basis, as I said before, that they will try and, generally negotiate in good faith and resolve the matter. That is always a bit of a blurred line, as you can appreciate, but that is definitely one of the obligations that the lawyers and the parties have.
Yeah, because one person's unreasonableness is another person's
Correct.
enthusiastic advocacy.
Correct.
Um,
But it is
I mean,
difficult. It is difficult, and it takes a lot of hard work from the lawyers at times, without sort of advocating what we do. But we do have to work hard sometimes, even with our colleagues, to
yeah,
basically try and get our clients to meet somewhere in the middle.
yeah, because the unreasonableness can be your clients, not just the other parties. Like
Correct.
it can,
But you
yeah,
know what? Every case has weaknesses and strengths, right? So every
mm,
side's going to see their own case the way they want to see it. But it's up to us as lawyers to say, yes, we understand you've got a strong case, but no case is perfect and it can still be lost, right? So there's still weaknesses on either side, and that's the job
that's
of the
really.
expert.
I think that's a point worth emphasizing because yeah, you're right. I mean, a lot of people I imagine come to you saying I have a rock solid watertight case, and this just doesn't happen, does it?
No, and again, to use the analogy of that building dispute, which again is not my area of expertise, obviously, but those cases are win or lose, right? So you sue your builder, you win or you don't, basically. This is not that type of case. You like from the lawyer's perspective, we may think the claimant's done quite well, but they will feel that they've lost, if that makes sense,
Mm,
because they haven't got what they felt they should have gotten. So it is such a discretionary area of law. There's such a range. I mean, people ask lawyers, solicitors, and barristers all the time at the outset of these matters,
yeah, what's
but
my percentage?
what's my claim worth, or what am I going to get? Or equally, the executor might say, oh, but what do we give them? And we just don't know at that stage. So because the evidence hasn't been furnished yet, so their affidavit has to be presented. We have to then have a chance to reply and see where it sort of sits, so we can then give a range. But we can never give a definitive number, even if it went all the way to trial. There is no way that any lawyer, no matter how experienced even that barrister is, that they could give you a definitive number. It's not that type of litigation.
And I think, again, before I started working in this
Yeah,
space, the idea of that level of discretion or grey drove me nuts because my world is a very quantifiable,
I
very
understand.
specific world.
Yes,
But the more you learn about this space, is the more you learn the humanity that's involved in this process means that
correct.
you cannot have a definitive answer.
No.
They're always going to be fluid.
I would say, and again, I'm probably speaking out of school here because I'm not a personal injuries lawyer either, but it's probably a little like personal injury law in the sense that there's a lot of factors that come into play in terms of the value of someone's personal injury claim, and how the courts in that jurisdiction assess, the merit of that type of claim and the quantum of the award as well. So it's not
Mm.
too dissimilar in that sense, but it's not clear cut, you win or lose, and this is the fixed amount you get. It never works like that.
Do you have people that want their day in court?
We do. Usually, when we break it down into numbers and risk for them, especially if there is a call to bank offer on the table, then they begin to change their mind. Not always.
Yeah.
And we do have, like I said, I won't lie, there are those that no matter what we say or don't say, go to court. Or, the ones that generally go to court have to have enough in the estate kitty to
Yeah.
warrant it. If the estate was worth 200,000, for example, you wouldn't go to trial. You'd be
Mm.
stupid. I mean,
Yeah.
and the judges would absolutely rip through you.
Mm.
If the estate was worth several million and people were being obstinate and wanted their day in court, despite us as practitioners trying to resolve it as best as we can, then you could let them have their day in the court if they really wanted to, because there's enough in that estate kitty to fund it, right?
But that's an emotional driver.
But that's an
not
emotional driver, correct.
Mm.
It does come down to, unfortunately, and this is not, being unsensitive, but it comes down to numbers. And I think people forget that in estate litigation because there is that emotional element and they have lost a loved one in the process, obviously. So it's fraught with emotion the whole way through.
Mm.
But at the end of the day, it comes down to a commercial deal. What can you live with? What do you absolutely need? And don't waste any more fighting this and just walk away. But also get your closure, have your emotion. And, where possible, you want to try and help these people keep those familial relationships or restore those. But once they go too far down the process, generally speaking, it's very rare for them to be able to reconnect with those people that they've been, in litigation with, which is sad.
And again, you're seeing them at that point in time. There's a very long history behind them, and there's a very long future in front of them. You're trying to get them through that period of time, and but there's only so much you can do.
That's right.
One final question I have, and I'm not sure if this is because I've looked for this information and it's a bit hard to find, but statistically, what's your read on the proportion of people that start off from a dispute and end up at that final hearing?
Well, prior to the pandemic, it was pretty much 90% of these cases would settle at mediation and not proceed to that trial. During the pandemic, we weren't settling many cases because it was all done online, unfortunately, and we weren't with the parties, so it was very difficult to get settlements. So, it was, around 50 to 60% of them were settling. It was abysmal. Since COVID, it was what I was saying earlier, or since the pandemic rather, I'm not sure. More of them are settling, but I'm also noticing people are willing to take them to trial as well. So I'm not sure of I don't think it's been reported as yet. Only the judges' associates would be aware of this, keep track of this data. But I would say that post-pandemic, it comes back to that or circles back to that point of discussion earlier, that I think there will be more and more, I hope I'm wrong, but more and more that do go all the way, just because of the higher incidence of blended families. People know their rights now, not only through forums like this podcast, it's in the media all the time. And social media channels, etc. People know their rights. They know what they can achieve or not achieve. And there is just that heightened sensitivity and need for, I guess, retribution sometimes when someone dies, which is sad, but that's just the world we live in now, unfortunately. But this I don't want to sound too sort of morbid about it because this, or pessimistic rather, this can all be avoided. That's the point I want to make. Like, it's not, if they get proper estate planning advice, which is not just about the will, but about powers of attorney, about stuff to do with trust, super, etc. If they get proper advice during their lifetime, this can all be avoided, no matter how difficult their situation may seem.
I lied earlier. I think I have one more question for you.
Yes.
Knowing what you know about the process, knowing what you know about the likelihood and how it can proceed and go over time, generally speaking, if somebody is feeling aggrieved about an estate, do you think they should pursue the dispute?
Interesting question. And I can't speak for everyone, Jordan, because everyone's going to have their own view on this.
It's all going to be so different, so variable.
Me personally, if someone rings me and they've said, look, Joe Bloggs has just passed away, I want to attack the will, I want to contest, or whatever it is, right? I always say to them, I'm very practical about it. Have you tried to settle this yourself? I'm conscious that we're dealing with a family unit. I'm conscious that those relationships can be destroyed potentially to a point of no return. So I always take that approach. I go, absolutely can help you. We're there to help you and guide you. We may give you some advice that can arm you, but we'll sit in the background initially and go off and try and resolve that. Have a discussion, family member to family member, and see if you can resolve it. If they then do that and feel that they've exhausted that avenue and then come back to us, that's when we would then initially, prior to formally launching into that formal litigation and filing the claim, try and resolve it with that party or that party's lawyer by way of negotiations. And again, then if we then still hit a bit of a stalling point and that time is ticking, then there's no chance. Then we have to if the client still wants to proceed. But there are a few points before we get to that is what I'm getting at. Having said that, though, we are guided by the client. If the client, in light of what we can do legally, of course, if they are very adamant, no, don't talk to this person, completely estranged, don't want to try that, you just go and do what you have to do, we'll listen to them as well.
Yeah.
It's a case-by-case basis, but I'm always of the view that, and effectively cutting myself out of a role essentially, but try and resolve it yourself first before you get us involved.
And I find, talking to as many lawyers as I get to talk to, I do find that there is this commonality that the really good ones, I think, avoid court and they avoid it as much as they can, and they follow a very similar approach to what you've outlined there.
Correct.
Sometimes you just have to do it. It's required. You can't get any further, but taking all those different off-ramps, I think, is a very, very good option. Teresa, thank you so much. Thank you so much for sharing. There's so much there because I think it is such a huge space and it's a very dynamic and fluid space. For anybody listening, how can they get in touch with you?
Yeah, so they can get in touch with us either via, we're on socials, iWills Legal, via our website. So I'm not sure if you can share that, but
we'll pop it in the show notes.
Yeah, so you can. So via our website, obviously, feel free to contact me directly or our office number or by email or give me a call. I'm always happy to help and have a chat. So there's no obligation. Just call us or email us. We're happy to always have a chat and see if we can help people. And as I said, if there is a way that they can resolve it without us, that's always, a great outcome.
Yeah. No, fantastic. Thank you so much, Teresa. And thank you again for listening to Life, Loss and Legacy. This is a Planning Solo podcast. If you do have any questions at all, our contact details will be in the show notes. Please reach out with any queries or concerns you may have. My name's Jordan Vaka. I'm an independent financial advisor with Planning Solo. Thank you for listening, and we'll see you in the next one. Thank you.
Thanks, Jordan.